Welcome to the mentor J.K. who's here, who's dialing in from the US. This is the first mentor session of the H.A.C.K program. And as you can see, we have J.K., who is currently a principal patent engineer at Grab. And before this, he was at Microsoft, where he managed a security patent portfolio of more than 6,000 patents. And before that, he was in various divisions in Microsoft, Azure, Bing, Windows, for more than a decade, working on various product development features. He is an inventor on 7 patents and author of multiple internet standard RFCs. So thank you, JK, for making the time and being a mentor to the H.A.C.K startups.
Thank you.
And yeah, so today's topic is something that's very relevant to all the startups, as you can imagine. So it's going to be about intellectual property, or specifically patents for startups. And this is well, if depending on which stage of your startup you're in, it really makes a big difference, right? Clearly, in terms of the innovation that you're doing within your startup, when you go and when maybe you want to talk to your clients, or you want to collaborate with your competitors, or you want to raise funding, one of the questions that comes up is, okay, what is your startup's differentiator, and how are you going to defend it? What is the moat, right? There can be many, and patents or intellectual property is one important one. So today, JK will be going over this broad topic, and the format that we have planned is we want to keep it as informal as possible. So we'll see as these sessions go on. So the mentor will start presenting, and maybe if there are pertinent questions that cannot wait till the end of the presentation, please feel free to ask. But if it can wait, then maybe we'll push it so that we have roughly about an hour or more of the presentation. And we do have enough time. There's a 2-hour slot that we have booked from 9 to 11. So we will have time at the end of the presentation, at the end of the talk, to have a pretty long Q&A session. And depending on the time available, we can even have one-on-one, sort of like 5-minute sessions. If there are particular startups that want to talk privately to the mentor, then we can facilitate that as well. We can jump on to a different Zoho call where there's only the mentor and that particular startup, and you can ask your specific question in private, if you want it to be confidential. So is that clear? Let me pause for a minute before I hand it over, and let's see if there are any questions on the format or the ground rules. Anyone? Any of the startups attending?
Yeah, myself, Dr. Dinesh, Cybersena. Yeah, actually, I have one doubt on idea patenting. Suppose I have one idea, solid idea, with a proof of concept. I want to make it a patent. Okay, so what is the I have a doubt whether to take international or Indian patent, and what type of what should be the direction future supposed to make, because I am very novel in this matter. So just let me know. So thank you.
Yeah, good question. So we'll hold. I think JK is going to address all of that. He has prepared a very detailed presentation covering the background of patents, what to apply, when to apply, where to apply. He has some examples as well. So please hold off on those patent-specific questions. I was asking more about the ground rules for the discussion. And before we start off, can I request? So all of you guys have logged in already. Ideally, from the next session, when you join the Zoho session, please put the name of your startup next to your name. Like how you see Bhavin Bansali has put Progest, Chetak has put CyberPact, right? So put the name so that we can associate your names with your startup's name. But I don't think you can do now. You'll have to log off and log in. So please do this from the next time. Yeah. And the other announcement I want to make before we start off is we are going to record this session. Yeah. Just in case, some of the startups were unable to make it, we will figure out a way to share the video of the presentation later on. All right. So just be aware that these discussions will all be recorded. All right. So if there are no more questions on the ground rules, I would again request everybody to mute themselves, and we will get started with J.K. Go ahead, J.K. Thank you.
Okay. Thank you, Rajiv. Thanks everyone for joining this session. Before I start out, I want to let you know, that I'm mostly been in security myself. So, we've also tried to add a few security patterns that we can look at as we go through the presentation. So as Rajiv mentioned, I've mostly been in product development in Microsoft, but in the last few years, I've transitioned to focusing on patents. And the number one thing I want for this presentation is for you guys to leave with a deep understanding of patents, such that that can be a competitive advantage for all of you. And I can tell you pretty much, after going through this this information, you should know more about patents than probably like 95% of startups out there. So with that, let's look at the agenda that we have for today.
JK, sorry to interrupt you. One
Yes.
second. I just want to double check with Abbas that we are recording, because I don't see anything on my window that suggests it is recording. Abbas, are we recording this?
Yes, it has started. I started 8 minutes back, it's it.
Okay, fantastic. Yeah, I don't see a red button on my screen. That's why I wanted to. Please go ahead, JK. Sorry.
Okay. Even though the title of the presentation is intellectual property, our focus is going to be on patents, because that's really the most important intellectual property for a tech startup. There are things, we'll briefly talk about, like copyrights and trademarks, but essentially only as to how they differ from patents. The number one thing I want to start out with is, how patents work and what patents are fundamentally. This is something even people who are patent attorneys don't really get fully. And this is important because this sort of gives you an idea of what can you do with a patent, and whether you really want to get a patent for some of your work or not. And we'll then take a quick look at how patents came about, and and then we will focus on looking at some famous patents, so as to sort of like dive in deeply and see how what sort of things can be patented and how different companies make use of patents. And then we'll talk about what makes a good patent, and then finally we will look at the patent process and sort of costs associated with that as well. And then we'll have some time for Q&A. But if you during the session I may call on you for different things, or if you have any quick questions, feel free to bring those up as well. So the first thing is, what exactly are patents? And before I start out, I'm going to ask maybe one of you, any of you, Rajiv, if no one responds, maybe you can start out by basically, saying, talking about what, what you think patents are.
Hey, this is Riaz from H.A.C.K Labs. So patent is something that, your innovation has to be secured and protected, cannot be copyrighted by someone else and make out of it, right? So we are ensuring the patent stays with us, for the intellectual or the idea or the things what we brought up to the market.
Right. Yeah, absolutely. Yeah. So patents protect your, invention or your innovation. But how do they do that? And so we'll see that here. So a patent fundamentally is a monopoly right that a government grants to an inventor. And the government grants this right in exchange for the inventor basically disclosing their invention in enough detail that someone else can take it and make a copy of it. So in return for the inventor, sort of giving up these details, the government gives the inventor a government protected monopoly of, commonly of around like 20 years. So the important thing here is that this right that the government gives the inventor is what is called an exclusionary right. So it is a right to exclude other people from practicing the invention. And by practicing, we mean like, from actually manufacturing the invention, using it, or offering it for sale, or, if it's done abroad, importing it. So that's the only right you get. You get this right to exclude others. You don't really get, through a patent, a right to actually practice the invention. And, we will actually see that later on as to why that is. But this is the most important distinction to remember here. And in this way, patents are different from other forms of intellectual property we talked about earlier, like copyrights or trademarks, both of which include an inclusionary right. That is, if you have a copyright to something, you have the right to use that and practice that. If you have a trademark to something, you have the right to use that trademark and practice that. But with patents, you don't have that. So the only right you have is the right to stop others from using what is described in the patent. So, so this bargain, again, is something that the inventors give up. The other thing you could do is, if you don't want to, other people to know what you're doing, is you can keep it a secret. Just like how the Coca-Cola, formula is a secret. It's been a secret for hundreds of years, and that's the only way Coca-Cola has, Coke has managed to survive as a company all these years. If they had actually just patented that as a formula, then they would have run out of the monopoly after 20 years. So that's something to keep in mind. However, generally, most tech inventions are usually discoverable by other people. And so, generally, in terms of what I've seen, it makes sense to patent things in the tech world. So, so that's really what patents are. So, patents themselves have a long history. In fact, the very idea of something similar goes back to ancient Greece, when chefs at that time were given exclusive rights to dishes if they disclosed the recipes. And so this concept was then lost then, during the Dark Ages. But around the Renaissance, when people were sort of like rediscovering things from ancient Greece and Rome, this concept came back in Venice and in France. But then the modern patent system really didn't get established until 1790, when the first U.S. Congress passed the U.S. Patent Act. And this act was actually written by Thomas Jefferson. And this was one of the very first legislations passed by the early Congress. And there was a lot of debate about whether a government, especially the government of a newly formed country, should be in the business of giving people monopoly rights. But then, people thought this was a good idea, and the legislation was passed. And later on, maybe 100 years later, people looked back and gave the Patent Act a lot of credit for a lot of the inventions that happened, in the U.S. During the 19th century, right after it became independent. So even today, the Patent Act that is there in the US, large parts of it are still the same as what was passed in 1790. So and then other countries sort of adopted similar patent systems, and in around 1890 or so, a treaty called the Paris Convention was signed. And essentially what the Paris Convention does is that it grants inventors from different countries equal status in terms of filing inventions. So you, as an inventor who's an Indian citizen, can go and file a patent in the US and be treated the same as an inventor from the US. In fact, you can file a patent in Pakistan and be treated the same. And so it's one of those very rare things, that's actually been adopted by almost every country. There's like a very, very small number of exceptions, like Myanmar. So other than that, pretty much most countries have adopted the Paris Convention. So what makes something patentable? I think this is something someone asked. Can you patent an idea? You can, but it must be. It must actually meet all of this 4 criteria. The number one thing is that it must be novel, and to be novel, something must not have been publicly disclosed anywhere in the world, and that is either by use or publication. And publication is like anything. It could be like a public blog post. It could be a research paper. It could be another patent. It could even, it could even be like, these days, of course, all of this PhD theses and all of that is available on the internet. But precedents have shown that even in the case where someone publishes a thesis that's only available in like the library of a particular university, it is still considered to have been publicly disclosed. And use, of course, means it's used as part of a product. So this way, so this makes it important for you to actually file the patent before you start shipping your product publicly. Now, of course, it is hard for a patent examiner to actually know whether, especially something that's sort of like not visible in the user interface, whether an invention like that has been disclosed or not. But they do expect that the inventor, sort of like it discloses, any of those public disclosures properly. So that's the number one thing, is that it must be novel. And the other things I would say are like less important, but we'll still like but there's still criteria that have to be met. The second thing is what is called inventiveness or non-obviousness, and this means that this invention that you're doing, it must not be some trivial invention. It must not be something where you just like replaced one component for another, without like, like a lot of like thinking behind it. And so this is, however, fairly nebulous standard. The law just says that the invention must not be obvious to someone skilled in the art. And this is the law in the US, and it's very similar in every country. And so there's a lot of debate on what constitutes someone who's skilled in the art, and what constitutes something being obvious, and so on. And courts in general do tend to give a reasonable amount of leeway to the patent examiner to actually make that determination. So that's something that can depend to some extent on the patent examiner. And then the last two criteria is, the first one of that is usefulness, that that the invention just not be like something that is decorative, for example, where you're just like changing the color or something, making it look pretty. So it has to have some useful value. And the last one is that, it has to be described in sufficient detail so that someone else can make a copy of it. So yes, you can patent an idea, but it cannot be something that is vague. Things that are abstract cannot be patented. For example, E equals MC squared, even though that's a great equation, to a lot of things, it is a fundamental so that cannot be patented. Laws of physics cannot be patented. Mathematical formulas cannot be patented. It has to have utilitarian value.
H.A.K, sorry.
Yes.
Guys, can you all please go on mute? Ashish, can you please mute? I don't know about others, but I hear a lot of background noise.
I think somewhere still Ashish is not connected to audio. Okay, Nitish.
Abbas, can you go ahead and mute everybody except J.K, please?
Yes, I've done it.
Yes.
I don't know why it is echoing. All on mute.
Do others hear the background noise, like a train, or is it from your mind?
It is due to some other reason, actually, not due to. 1 minute, I'll just do.
I think sometimes the mute takes a while, and so I see suddenly some people became unmuted.
Can
Okay,
mute
since
all
you're
and then
already,
unmute? I'll mute all and unmute YouTube.
yeah, please do.
Even if you mute all, I'm getting this sound. I'm getting this noise.
Right. Okay. As long as it seems to be getting a little better, so let's go ahead.
Okay. Good.
JK, you can proceed. We're able to hear you.
Okay, sounds good. Let me go back. Okay, so we were talking about enablement. And so, yeah, enablement just means that the invention has to be described in enough detail that you can make use of it. So those really are like the 4 criteria that make an invention patentable. So the thing where this sometimes comes into the picture for computers is things that are like just saying that something in the real world you're just taking and implementing it in the computer and thereby making it more efficient. That is generally not enough to make something patentable. But other than that, like things that improve most security things generally are considered patentable because they improve the computer itself, and so so most security things would be patentable. Things like AI algorithms that can depend. Uh, so, but yeah, if you have more specific questions, we can talk about that later. So let's actually start looking at some examples. So if you look at a general patent, it will have all of this information that you see here. It will have the time the patent was filed, I mean, the day it was filed, the day it was granted, the inventors who came up with the idea, and the owners of the patent, are referred to as assignees. Typically, if you're employed by a company, the company has makes you sign an agreement when you join that they own all the intellectual property that you generate. So the company will be listed as the owner or the assignee of the patent. And then you'll see like a patent number when it's issued that is specific to the patent office. You'll see the name of the patent office, of course. You'll see a list of references to other ideas that are similar. You will see the name of the examiner or examiners who looked at the patent. And then you will see a description of the invention, including an abstract, a more detailed description of how it works, maybe a sample implementation. You see diagrams, and then finally you'll see, what are known as claims. It's not here in this one, but the claims are really concise legal language that describe what the patent is about. And the claims, for many people, is the most important part of the patent. fact, not for many, not just for many people. In fact, for almost every patent, the claims are the most important part of the patent. So, we'll take a look at a simple claim here. And, this is just something that I made up before we actually go into actual real world example. So this, so let's say, you have these 3 patents which were filed at different times. Patent 1, at some point, some inventor said that, hey, I have an idea for something called a table, and, it needs at least like 2 legs. And so they file a patent. They describe, how to make a table and all that, and then, their claim says table with at least 2 legs. So, this is the concise description of their invention.
I'm posting regarding common mistakes we make in security and compliance implementation. And I actually started this, I had a recently baby boy and...
Sorry, was someone talking? I think they're muted now.
Yeah, not sure. I mean, everybody seems to be on mute.
Okay. I heard someone talking, and then it looks like they muted themselves.
Yeah, we all heard. Looks like crosstalk.
Okay. So yes, so that's the first patent. The second patent, sometime later after the first patent, another inventor discovers that a table really works best if it has 4 legs, and so they go and they file for this patent 2, and the claim says a table with 4 legs. And then sometime after that, like with all modern technology and stuff, people figured out that, hey, you can actually like make tables with like 2 legs or even like 1 leg, and make it work. And so that person then goes and files a patent with a claim that says a table that has no more than 2 legs. So you have these 3 patents, and then you have products, that you see on the right. Let's take a look at the first product that you see there on the top right, that is a table. So looking at the patent claims on the left, can you maybe take a guess as to, what claims map, or what patent claims, which numbers map to this product on the top right? Anyone?
Okay, I think people are still on mute, so I'll go ahead with patent 2 table with 4 legs, and then the second one would be the patent 1 table with at least 2 legs.
Yeah, so both patent 1 and patent 2 correspond or map to the product on the top right, So, so in patent terms, you say that this product that you see there on the top right infringes both patent 1 and patent 2. So now you see perhaps why, if the inventor, if the person making this product, let's say they are the holder of patent 2, and they came up with this idea, but it's still not enough for them to practice their invention and make their product, because someone else has another patent over the general idea. So so that is why patents are an exclusionary right, because oftentimes it may take more than one patent to implement a product. And so, even like a feature, it may take more than one patent to do that. So similarly, if you see the second product, that sort of has two legs, I'm only counting this vertical one as the leg. So, if you say that has two legs, then that means, it infringes both patent 1 and patent 3. Right? Yes, yeah, patent 1 and patent 3. And then the last one really only on the bottom right, it only infringes patent 1 because it doesn't have 4 legs, and also it doesn't have no more than 2 legs. So it has, it doesn't have less than 2 legs. So that's like an example of like claims. Now we'll actually look at some real world patents. Before I go into detail, I wanted to start out with like a simpler patent called a design patent. A design patent is essentially something that covers how something looks. Generally, when we talk about patents, we talk about what are called as utility patents. And utility patents cover how something works. And, we'll see that right after this. But let's start out with the simpler one, the design patent. So because it just covers how something looks, the claim is generally very simple for a design patent, and it would say something to the effect of the design of a device as shown, or or it may even have a textual description of the design. If it was for this, it would say something to the effect of like a rectangular device with rounded corners, a circular button at the bottom, and some kind of like a slot for a speaker at the top or something like that. So because the design patent really only covers how something looks, it can easily be worked around usually by changing the look of the product. So, so this product, like anyone wants to take a guess as to which one this is? Rajiv, it might have to be you.
iPhone.
Yeah, this is the original iPhone design patent. And, this was a patent that Apple actually used to sue Samsung. We'll see another patent that Apple used as well. So this one, so there was a lot of debate about like the rounded corners and so on. And then, Android, of course, then, it basically has these like 3 buttons, or before it used to be physical hardware buttons. Now they're just like typically icons, and so that way they could work around Apple's design patent. If they also had like the same circular button at the bottom, they would be infringing this design patent. So if the design patent can be easily worked around, why would someone file a design patent? Design patents generally are used to protect premium products. And so this premium product would be something where the price of the product is significantly higher than the cost of manufacturing. So in this case, the iPhone, for example, Apple doesn't. So other products where it might be used are like a Nike shoes or Gucci bags and so on, other kinds of premium products. Yeah, and so so that's essentially typically the use case of design patents. With our technology patents, design patents are often used for user interfaces to protect, if you have a unique way of having like a particular user interface, like having the user select something, for example. So those things can be covered by design patents. They could be covered by utility patents as well. But design patents are generally granted much more quickly than utility patents. And so for this reason, sometimes or many times it may be, if you're patenting something where you can patent it based on the look, you can even start by filing like an initial design patent. Design patents typically will be granted in a period of several months or within a year usually. So that's a design patent. Let's look at utility patents. So here is another similar feature that or patent that was used in the Apple versus Samsung litigation. And if you look at the diagram on the right, the diagram is not part of the claim. It's just here to make it easy to understand. So if you look at that diagram, would you or read the claim? Can you take a guess as to like what feature this patent covers? Anyone?
The slide of the screen.
Yeah,
it is on the screen. Yeah, that screen.
Yes, yeah. This is the so-called, I guess, slide to unlock feature, where on Apple phones you unlock by sliding the screen, and that prevents the screen from getting accidentally unlocked when it's in your pocket or you're doing other things. So if I actually remember this correctly, this also used to be present in some Android phones, like about 7, 8 years ago, or something like that, before Apple actually sued Samsung, and and then people said, okay, that's we don't want to mess with that. At least the major manufacturers all try to get out of it. So if you look at this particular claim, it's definitely more involved than the last simpler claim that we saw. And this particular patent, this particular feature, there is also a design patent that Apple filed as well. And the design patent, the claim in the design patent would be, is something like, what we saw in the last slide. It would basically say the user interface design as shown in the diagram. And what is shown in the diagram is this vertical bar, and you being able to slide something with that, not vertical bar, but horizontal bar, and you being able to slide it across that bar. But if you, the problem with that would have been that someone could work around that by having a vertical bar or a diagonal bar, or even something that is circular, But if you look at the patent claim itself, the utility patent claim, it covers all of those scenarios. It basically says it's a method of unlocking a handheld device by detecting a contact with the touch-sensitive display and then continuously moving the unlocked image and then unlocking the handheld device if the moving the unlocked image results in movement from the first predefined location to a predefined unlocked region. So this actually covers all of those cases that I talked about, the diagonal, circular implementation, all of that. So a good, well-written claim will cover, the full aspect of the invention. And typically, when you're filing a patent, when you're paying lawyers a lot of money, this is what you're filing, or this is what you're really paying money for, is for them to understand both the invention fully and also the patent language, and then craft these claims in a way that it covers the broadest possible aspect of the invention. So that's another patent. Then we'll see one more. Actually, for this patent, I'm going to go. I'll let you guys maybe quickly read this claim, yes, and then I'll show you a diagram here. And the important part to note here in this diagram is the one marked 103. That's the core of the invention. Anyone wants to take a guess at this? As to what
H.A.K, can I ask you a quick question?
Yes.
In the previous slide, right, the sliding window.
Yeah.
If I do the sliding from right to left, will it avoid the infringement?
No, it will not, because if you read this language here, it says it's just like a movement. It doesn't say like a movement from left to right. Again, if it was a design patent, then you will have all those problems. But here, they've written it such that, there is no left to right or right to left. It just says, as long as you move it from one point to another point, and that results in unlocking, that basically you will infringe the patent.
Okay, that's brilliant. Yeah, thank you.
It makes sense? Okay.
Yeah, I think that the point there is also that when you write a claim, when you write a patent, right, and this is something that typical patent attorneys will help you, is to make the claim as generic and as broad as possible so that it covers much more the one in your product. Right?
Yes. Yeah, it is like a trade-off that the people who write the claims have to straddle, because you want to make it as broad as possible, but at the same time, if you make it too broad, then someone else would have already maybe have disclosed it. So so you have to make it broad enough that it's still novel and meets all the patent criteria, but not too broad that that someone else can claim to have already done it. So that's really the tricky part. So this feature, anyone wants to take a guess?
I think this is the stage of where Amazon was trying to move to the shopping cart to from the garage to the business.
Yes, sorry, I can't hear you very well, but this is the, I think you said, this is the Amazon one-click patent.
That's right.
Yeah, and Jeff Bezos is one of the inventors on this patent, and the patent itself, only recently expired, and Amazon, a lot of other people were very hesitant to have this feature until this patent expired. And Apple, since we were talking about Apple in the last patent, uh, Steve Jobs wanted to use this idea when Apple relaunched the Apple Store in 2006. So he called Jeff Bezos up and paid some amount of money. I know we don't know exactly how much, but we paid him some amount of money, paid Amazon some amount of money to be able to use the one-click ordering in the Apple Store in 2006. So that, and now we have like a reasonably good idea of some patent claims. We can look at one or two security related patents. So this one, I put it here because it's my most recent patent. And if you read this, what it says is that it is a secure computing device. You're establishing a device claim that identifies the device. And you're establishing a policy to patch the device, and then you're doing some application whitelisting that only specific applications can be run, and then you're presenting, you have some inbound firewall policy, and then you have a virtual machine on this device, and the virtual machine actually allows at least one application to run that you cannot on the base device itself. And so that's the concept. And the way, if you read the patent, the way this is actually used is it's something that Microsoft uses to manage all its cloud services. We used to call it like a secure console, and then people started calling it a secure admin workstation and so on. The idea is that the workstation that you're using to manage your production services remains secure. It doesn't have malware. You can run AD and so on. But that is all based on some kind of a blacklist and you maintaining the blacklist properly. So, so for something like Azure, which has a lot of customer data, we wanted to go with something that would be harder to compromise. And so the base device that people use the developers and operations people use to connect to Azure is one of these devices, and the base device is very locked down. And then if they want to do something further, like, browse the web or something like that, they have to do it with a virtual machine that is inside this base device. So that's the idea, so that's a fairly straightforward one as far as security is concerned. Here is another, famous security patent. It is fairly involved. If you're into crypto, you may, know about this. This is called the keyed Diffie-Hellman. Diffie-Hellman itself, the algorithm, it establishes a shared key between two parties. But then, the two parties are not authenticated. So with authenticated Diffie-Hellman, you can authenticate both parties with the key and also establish a shared key, without using a third party. And, but this was patented, so it never got used. For 20 years, at Microsoft, at many times, we were wondering, if we could use it. There were a lot of scenarios we wanted to use it for, but we couldn't because of the patent that, Merkel, Diffie, and Hellman had on this. So that's another security patent. This patent, I'm not going to go into the details, but you can take a look at it. This is from FireEye, and this sort of covers the core aspects of their product. And they filed it when they started the company. So that's one. And this last one, this last one is, I don't know if I actually, I don't have a diagram of it, but you can actually look it up. This is Mark Zuckerberg and Facebook. They filed it in 2006. And this is basically the privacy page, user privacy page that you see in Facebook. When you click on your profile and your privacy settings, it shows you, what you've shared, what you've not shared, and so on. And this patent basically covers that page basically. So that's another example. So we covered all of this. So what makes some of these patents, in fact, many of these patents, a good patent. The number one thing that makes a patent a good patent is that someone else other than you, the patent holder, is likely to implement that. If you're the only person who's going to implement it, the patent is not very useful because, as we saw, patents are exclusionary rights. You get the right to stop someone else from, making a product that the patent infringes. So essentially, so that's the number one thing for you to think of is, will someone else try to do this? If so, most likely your idea is first patentable. And number 2 and number 3 are less important, but it's sort of good to have. Ease of detection just means that, you have some way of detecting that someone else is using the patent. Because without that, it's sort of like hard to go after someone else. And so, for patents that are based on the user interface, this is very easy. But even for other patents, you can do some kind of A/B testing or experimentation to actually see if the patent is being infringed or not. And then the last one is that if what you're doing is just one of many different alternatives, again, it may not be worth patenting because even if you were to go after the first person, they will just change to like an alternate system, So you must have some unique advantage that, that they would not want to give up. So that's so those are the three things that make a good patent, and definitely number one is the most important. So with all that said, what does it sort of take to file a patent? The number one thing is that you have to ask whether it meets the patentability bar that we talked about. If yes, then the second question is figuring out how to file. You can file through an attorney. Like in the US, I think in India it's generally like a few lakhs. In the US, it's the average cost for like a computer technology sort of patent is a software patent typically is around like $10,000. You can file what is called a provisional. This is what you see when you search for filing a patent on the web, and people say, "Hey, for $1,000, I'll file your patent." A provisional is something. Essentially, what a provisional is that it includes only the patent specification, but not the claim, which is the most important part. So a provisional really doesn't really allow you to go after anyone else. All a provisional does is that it makes it makes it impossible for other people to patent the same idea. So it is essentially like like publishing your idea and making sure no one else files a patent after that and tries to say that they were the first to come up with the idea. Also, a provisional you can even later on convert to a regular patent by adding claims. But generally, as we saw, adding the claim is the most difficult part. The last thing is you can file by yourself. Most patent offices will allow you, the inventors, to represent themselves with the patent office. If you have to represent someone else, you have to be registered as an agent. Typically, you're an attorney. In some situations, you don't have to be an attorney, but you have to pass an examination conducted by the patent office. So that's only if you're representing someone else. But for your own patent, you can file it typically.
H.A.K, 1 second. Sorry to interrupt. I think somebody's patent has not worked or been actually. Any of the attendees who have a car, have a job, or if you're parking next to where you are, because there's a lot of parking that I could hear. So, if so, can I request everyone to unmute and mute again? I could hear somebody breathing really heavily. Okay, go ahead, J.K. I think it's gotten better, but I can still hear somebody breathing really close to you. That seems to help.
Yeah, at least the dog is not barking anymore.
One quick question.
Sorry, is someone asking a question? We can barely hear you. So maybe you can type your question.
Yeah, I don't hear a question. I can hear somebody breathing really close. Okay. But yeah, please, if you have a question, please add it to the chat.
Okay, yeah. So, once you decide how to file, if you're working through an attorney, the attorney will, so Rajesh asked the question, can we file a provisional to start with and then convert to a full-fledged one? The answer is yes.
So, J.K., maybe can you, I think that's an interesting one. Can you add some more details? Can you share some more details on what is the provisional? Is it just a patent without claim? Does it cost less? Can you do that yourself? And does it have a specific time period before which it has to be converted to a full one?
Yes. Yeah. Generally, there is a time period, which is usually about like a year to convert the provisional. Hey, can you guys hear me?
Yes, we can hear you.
Oh yeah, this the noise is someone finally muted, so it's so weird.
The background, I think the hiss went away.
Yeah. So yeah, the provisional, yes, usually the time to convert is about a year before you actually have to file the patent with the claims. And yes, the provisional is basically a patent without the claims. And because you don't have the claims, it is less stringent, so you may not even have. Sometimes people would just like, are in a rush to publish a research paper, so they would just like send the research paper to the attorney, and the attorney would basically sort of like take the research paper and file it as a provisional. The issue with that is that later on, when you have to go and file the claims, is that like you may find that you did not add the proper information to actually explain your claims well. So because if you later on change anything in the provisional, then you lose what is called is your priority date. So let's say on January 1st 2020 you file your provisional, but then like 8 months later, then you add convert it into a regular one by adding claims. Even though in like you did that in August, you only add the claims in August, your patent still counts as though it was filed on January 1st, which means that anyone else again like trying to patent, they will be disbarred, and so you get the benefit of what is called like this priority date, which is establishing that you were like the first person to file that. So yes, but a provisional can make sense in many cases. If you're in a hurry, you don't have the money to actually file it, you don't want to think through the claims, at least you're one protecting yourself from someone else copying the idea. But then you will be describing it in like sufficient detail, right, like for someone else to look at it. But you're giving all of this detail, but you're not getting any claims for it. So that's the thing you have to consider. But again, if you feel like, oh, maybe this idea will not make it, and I don't want to spend a lot of money or time right now, you can file a provisional and then figure it out in that year that you have.
H.A.K, another quick question. So what is the stage for startup to file the patent? For example, when the startup start, it's about the ideation, right? Then we are converting to the POC, then it comes to some functional development, then we are making the functionalities working, then we are launching the product, then when the customer engaging, they are starting using the product, right? So with this journey, like which is the right stage to file the patents? Maybe provisional or the claim. Can you just give a guidance on?
Yeah, I think the provisional versus the regular patent with the claims, that decision is mostly a decision that you have to base on like, do I have the time and money right now, or either time or money for me to do a claim based one. If not, then then maybe go with the provisional. So that's the basis for that decision. As to when you want to file it, as soon as you have enough detail, because you don't want someone else to file it before you. But the bar to filing is that you have to have enough detail. We talked about enablement, so it has to be described in reasonable detail. If it's like too early, if you just have a general concept, at that time you may not have like enough detail of how the actual thing will work for you to file. but still, it's not necessary. If you can spend the time to actually write it out, like in enough detail, you can still file it. You don't need even a product to actually file a patent.
Yeah, thanks, J.K.
Okay, sure. So
hi, this is John. I just got another quick question for you.
Sure. Yeah, absolutely. Go on.
From another company, we had filed a patent in 2018, and
okay.
we received the patent in May 2020. So about a month, not even a month back, actually.
Okay.
2 weeks back. So we received the final copy. Now, during this course, whatever we had filed, we also see that there are other companies who have been using this technology. But now that I have, or we as a company, we hold the patent right, what kind of privileges or what kind of benefits can I start looking from this approval of the patent?
Yeah, you can either through an attorney or typically through an attorney, or maybe through some other person. You can contact or even by yourself, you can contact the other companies and say, hey, I have a patent. I think you're using my patent. You should pay me some amount of money to license my patent. And so essentially, people who are infringing your patent have to pay either a license fee. You're not required to actually let them pay. You're not required to let them pay a license fee and continue using. You can actually file for an injunction and stop them from using your product at all. But generally, I think most people are happy to just have some amount of money. So you can so you can basically ask for money, and that's usually what happens in like most of these like patent cases. They will contact the other party and see if they can get to some kind of resolution. Does it make sense?
Yes, it does. Thank you so much.
Yeah, and if they don't play ball, then or they try to ignore you, then you have to make a decision. Is it worth you filing a lawsuit to force them to pay? So that's a decision you have to, and that's also something you have to keep in mind as well, is that enforcing the patent can take some resources, but again, you don't need to. Sometimes people may not want to do the enforcement themselves. You may either now or later on during the lifetime of the patent be able to sell the patent to someone else as well. There are lots of so-called patent brokers, patent trolls, who basically make their money by buying patents from inventors and then going after the companies that are using the invention, and that's their business model. And so they're able to buy patents from small inventors or inventors who don't have the resource to go after big companies, and they do it themselves. So that's the other option.
I have one question.
Yes.
So let's suppose you have filed a patent in US, right? And somebody is using that patent somewhere in the globe, maybe let's say in India. So how more from a lawsuit perspective, because India will have their own land of law and stuff like that. So how, if somebody is basically raising a concern about people using their patent out of US as a country, how that enforcement happens, and typically more on the length, right? How much time it takes, because every country will have their own jurisdictions and law enforcement stuff like that. So is it very common, or it has lot of concerns in this scenario?
So there are different enforcement mechanisms, and most enforcement mechanisms are through the courts. And so it can depend on the courts, but even in India, where courts are sometimes known to take lots of time, there have been many patent decisions, forcing companies to, pay lots of money. I think, what is this phone company, Oppo, went through something like that, where they had to pay money, I think, to Ericsson or something. In the US as well, it is it is a similar process. Plus, in the US, there is an additional process called the ITC, or International Trade Commission, so that in most phones, for example, right, are like made in China or something and imported. So you can go to the trade authority and say that, hey, you should actually, because these things that are being imported are being banned, are infringing my patent, you should just ban the import of this. And that is actually a faster process, like in the US, for example. And so a lot of people go through that process. So those are like sort of like a couple of options that you have. Does it make sense?
Yeah.
Okay.
J.K., there is a question on the chat from Kavitra of Labs. Kavitra, can you please go ahead and ask?
Yeah, hi J.K. And my question is regarding, could you please give us some information regarding the inventor filing the patent himself, like the areas where he has to be more careful and where the mistakes might come?
Got it. Yeah, the most important part, like we talked about, will be the claims. One thing you can do is, you can find someone maybe who has some patent expertise to look at the claims. Maybe you can even pay an attorney just for like that part to give some specific guidance. I would say drafting a claim is not too difficult, but there are some gotchas. Like, for example, if you say in patent language, let's say I file a patent for the table, and I say table comprising like a flat top and 3 legs. That means that table has to have exactly only that flat top and 3 legs, and it cannot have anything else. Even if someone, it's almost like a design patent, because if someone adds something else to that table, maybe like a 4th leg or like a sidebar or something like that, then it will not infringe that patent. The proper thing there is to say consisting of, because in patent language, consisting of means that your invention is not limited to just those things. And the word comprising, even though it looks very similar, right? Comprising is typically used for things like drugs and other chemical formulas, where you are describing a very precise quantity of everything. There are like some gotchas like that. Other than that, I think, you're generally fairly safe. So, you could just draft that claim and have someone review it. And I would say that's probably like the way to go if you're worried about it.
And J.K., there is also something about making, instead of lumping the whole patent into 1 or 2 claims, making multiple independent claims is supposedly better, right?
Yes, yeah, absolutely. You want to make sure that, if a patent is struck down, if a patent is struck down or a claim is denied, it only generally refers to that claim. So, which is why people generally try to have multiple independent claims, and they may come at it from like a different angle. Let's say you have something that involves both like a client-server interaction, right? Like, one couple ways to write this claim would be, one would be from a purely client-side perspective, that you're describing the claim. So you're essentially, the claim will say, okay, what is claimed is a client device that sends data X, receives data Y, and does XYZ with that data. And then, on this, if a server side claim might be something like, oh, the server device that receives data X, and then does some processing, and then sends out data Y. Essentially, you're describing the same thing, but from like a different perspective. One mistake often people make with this sort of like a client-server system is that they generally include both the client and the server in the claim. And what happens is that, oftentimes, like, client is made by one guy and server is made by another guy. Maybe it's Google, and client is your competitor. And each person by themselves doesn't actually infringe the patent. Only together do they actually infringe, and that results in what is called as divided infringement. So when you are filing a patent, so that way, like, just think of, okay, who will be the infringer, and it's always best to restrict the claim to like a single device if you can, a single component, but generally at least like a single device.
Great, thank you.
Okay.
There's one more question. Actually, you're not done, right, JK? So there's one more on the chat. Why don't you finish up, right, and we can go to
Sure. Yeah. That's a simple question. I can, probably one of the cheapest or the easiest ways is Google has a site called patents.google.com. And if you go to patents.google.com, in fact, I don't know if you guys can see this, but I'm trying to go here. And then if you go to advanced search here, you can just like type like the company name here, SI name. Let's say it's Google, and let's do a search, and then you'll see everything, every patent that Google owns. So,
do you want to share that window? It looks like you're sharing only your presentation.
Oh, sorry. Okay, so let me do that right at the end. Then that way I can just like overwrite this presentation. I don't know how to share the other window.
Yeah, no problem.
So, okay. Yeah, let me finish the rest of this. Essentially, so yes, so after you figure out whether you're filing through an attorney or by yourself or just a provisional, you would do what is called a prior art search, which is basically, go to Google Patents, look at Google Patents is pretty much going to be mostly enough, because in Google Patents, you can also search research papers. But if you want to look at some products as well, you can search in Google. So, think about like the key aspects of your product and see if someone else has, like already like disclosed these ideas. And then if not, if you feel it's still, fairly novel, that, then you draft a sample claim, and then the specification, depending on whether you're doing the provisional or a regular patent. And then, then you would just like file it with the patent office. And usually there is some fee. In India, there's the Controller General of Patents and Trademarks that you would file it with. and the US, there is the US Patent Office, and there's something called WIPO, which is an international authority as well that you can file it with. And typically, if it's a regular patent, it may take a year or two before the patent office gets back to you. Some countries will allow you to get the patent granted faster by paying some more money. Generally, it may not be needed in some cases, but in other cases, depending on the country, they may want more money for an accelerated examination process. So that's essentially it. If you have any other questions, let me know. Otherwise, I'm just going to go to patents.google.com here and sort of show you how to do this. So just go here and you type in the assignee, say Google, and then you'll basically see all the different patents that Google has.
Check out these pictures.
So okay, any other questions?
JK, I had one on this particular part. Right? So the Google patents, does it cover India as well? As in patents filed in India?
Yes, it covers India as well. Here, I will show you. You can go look at the patent office here, and then just go. What is India is probably IN, right? So let's see.
Okay.
Oh. Let's see, Microsoft. Some of these offices, Google Patents may not have the best thing, but see, Microsoft here, for example, has, sometimes some companies will not file in certain countries. So, you can see here, the Indian, this is a Microsoft patent that Microsoft has filed in India. Microsoft, for example, will only file a fraction of the patents in other countries because the US is the major market. You can also, the Indian Patent Office has a site as well. I've used it. It's a little convoluted, and they make you enter captchas at multiple stages before you can actually access the patent, and their search is definitely it's not like Google search. So I would say start with Google Patents, and then if you want, you can go and look it up in the particular patent office as well.
Got it.
Okay.
Let's pause to see if there are any other questions that the startups have. I have a couple of ones that might be interesting to all the startups myself, but I'll wait. Anything else, folks, on the meeting? Okay. So JK, can you? So for all the startups here, right? They're all, cybersecurity startups based out of India, and some of them potentially have clients in the West as well, right? So US and Europe are obviously big markets, and I know some of the companies here have or are engaging with prospects in, let's say, the Middle East or Southeast Asia, right? So how would you, again, there are multiple things, right? One is, when do you file the patent? And that is something you answered. You don't need to even implement anything. As soon as you have an idea which you think is going to be interesting, mostly for others, like you said, to exclude others from implementing, you can go ahead and file. So how would you go about that process, right? Would you file here, file in the US, file for the majority of the countries, and all that has an associated cost and legal cost. It takes time to adhere to those jurisdictions as well. So
yes, I would say probably the US is the best place to file. And I'm not saying that because I'm here. It's just because, it's probably the largest market, right? And again, with the patent, you don't get the right to implement the product. So it doesn't matter if your thing is in India, if 90% of your business in India, maybe even 100% of your business in India, really what you're trying to do is preventing the people who are trying to get some money for it from other people who might implement it. And so for that reason, I think it makes sense to actually file in the US. There are two reasons you might prefer to file in India first. One is you feel that there are going to be a number of competitors in India, and you want to stop those competitors completely from copying your idea. So that case, it makes sense to file in India first. So the other case, I'm trying to think what I was thinking for the other case. I'm sorry, I forgot what the other reason to file in India first would be. If I remember, I will let you guys know.
Be cost effective for the reputation.
Yeah, as you guys know, in India, this is a government office, and so it does take some time. Perhaps a little bit more in the US too. Government offices pretty much everywhere are a little bit slow. But generally, it is a bit. It is definitely faster in the US. And in terms of enforcement too, I think we know the courts can be slower in India. So that's a trade-off that that you have to balance. Cost-wise, really, the cost of the fee of filing itself is not that much. It's like in the US, you can file as what is called a small entity or a micro entity, and it's only a $200, $300 or something like that. In India, it's a few $1,000s. So it's a wash, really. I'm only talking about the cost of the filing fees with the patent office. Cost of the lawyers can be, is a bit lower in India. I would say maybe half or less. So that may be something you may want to consider if you're filing with the lawyer, or maybe who knows, maybe a lawyer, a patent lawyer in India, for example. My experience has been that patent lawyers in India generally, are a rare species, and for that reason, you probably won't end up spending, saving that much money anyway.
Good point. So for all the startups here that presumably don't have a US entity, right? They don't need to have an US entity to go file a patent in the US, correct?
Yeah, you don't need a US entity. You don't even need a company. You can just file as an individual, and and then you can assign the patent rights. Your company in India can license the patent rights from you, for usage. Some of these guys, startup guys who are very creative, they do things like that. With WeWork, for example, the founder basically said that, hey, got all this funding, but then he ultimately still owned a lot of rights associated with WeWork. So you can do like that. I mean, you can do something like that, still be above board. Maybe like give a perpetual license to your company. But again, that's not needed as well. You can just file as your company in the US Patent Office too. You don't need like a separate company in the US.
Got it. All right. Any other questions? No?
So, JK, a patent filed in, say, US is still applicable worldwide, right? So, you mentioned earlier that if you think there's going to be competition in India, then you're better off filing in India. Why is that?
Yeah. It's because the patent is only enforced, like a US patent is granted by the US government, so it's only enforceable within the US. It can, however, you can use that to file a patent in India, and the Indian different patent offices, if the patent has already been granted in another country, will give you like a faster path to a patent in their country. But ultimately you still have to file a patent in each country to get it granted. There are different things like this WIPO thing I mentioned, which is like an international filing. These things sort of make that easier, but ultimately, for the final step, you would still, so with the WIPO, or the World Intellectual Property Organization, you can file what is called as like a PCT application. PCT stands for Patent Cooperation Treaty. And that you can file with any office, and using that as a basis, then go to the other offices and ask them to grant an individual patent in each office. But still, you have to do that step and go to the patent office in each country that you want the patent to be enforced in, and get it ultimately granted. Does it make sense? So so the patent jurisdiction is only within the scope of that particular country.
Yes. So, then thanks.
JK, the loophole over here is, for example, if I have filed a patent in India, if I don't have a patent in other countries, someone can copy and use it at other countries, right? Like I will not have any.
Yes. Yeah, they can copy and use it. They cannot, however, file a patent in the US. After you filed in India, they cannot file a patent, but they can still, copy and use it. However, generally, like in the US, for example, you have 1 year after you file for your patent in India to then file a patent in the US. So another thing, I mentioned this Patent Cooperation Treaty. With this particular treaty, once you file this initial application, this international application, you have 36 months after you file this PCT application, which is essentially just like a patent application that you file with WIPO. You have 36 months to then pursue the patent in any country that is a member of the PCT, which is pretty much almost every country. So that is one way if you want to sort of, and like most big companies sort of will use that method because they want to keep their options open, and they will see, and then like after 2 years, if they see like, okay, this is an idea that will gain traction, then they may actually go and find that in different countries. Whereas with the provisional, you get 1 year. With this PCT, it's and the provisional, some countries don't recognize the provisional. The PCT is an international concept. You file it with WIPO, and you get 36 months to then file your patent with any particular individual patent office.
Great, fantastic insights. We do we do have several attendees here, and looks like some of them have gone through this patent process, either in the US or in India. Does anyone want to share their story of how they went about it and what the reality is? Has anyone filed an Indian patent?
Yeah, maybe I can share my experience, but it's not for my startup. I have did this patent filing for my previous job. So this was a group of people who invented some product, which need to be filed as a patent. So we went for a provisional filing, and when we are doing the provisional filing, we came to know about some of the infringement, the product which is already available in the US market. But this product is majorly targeting the US market as well. So what we have did is we have engaged the IP attorney who worked with me to find out all the infringement as a comparative analysis. And we came up with a list of infringement compared to that product, and we did some kind of tweaks in the product here to make that it's not infringement, and they successfully obtained the provisional patent finally. Just my experience.
Patent was in the US or in India? US, yeah.
Yeah, it's in US. Yeah, it's in US.
Okay.
But the guys who are worked, they are based out of India. They are doing they're doing like IP services from India for the US patents.
Got it. Has anyone gone through this process here in India, or people have just looked at the US market for now? Okay.
Yeah, I think I've gone through the Indian process, but then Indian process was more from the attorney side to a large extent, because I think that was one of the major. I mean, of course, once we have done the initial provisional and all those things, and when we did in 2018, and then from there to getting the actuals was to a large extent was the major role. From the legal perspective was paid looked into from the attorney side, and of course about a few weeks back is what we received the document from the government on the patent certificate from India.
All right. Any other final thoughts, JK, or any other questions? Otherwise, there are so JK, there are two companies that have requested for a very brief one-on-one with you. Right. So we could do it right away, like a 5-minute session. Is that okay?
Sure.
Okay. So before we go to that, any other final thoughts? So I think okay. So looks like we are mostly done except for the one-on-ones. So thank you. Would like to thank JK for taking the time and the effort to share all the wisdom when it comes to the patent process. And personally, I have found that there are a lot of things that that are there, but there are just too many processes, and obviously there is legal stuff involved. So which country, how do you go about it, how much does it cost? Sort of multiple factors that come to play, which really push the startups to delay filing for provisionals or filing for the actual patents themselves. So hopefully this session has cleared a lot of those things up. And if there are any further questions that come later on, in the upcoming months, feel free to send those questions to us at H.A.C.K, and we will see how we can coordinate with either JK or with some of the other mentors. In this case, specifically for the patent process, right? We can evaluate what the best routes are to help you either here in India or with the other markets that you're targeting. So with that, thank you, JK. Fantastic insights. And for the Yeah, so we are done. So if you guys don't have any other questions, or if you're not Riaz or Kavitra from Crossbow, please feel free to leave this meeting. And at this point, I think, Abbas, we can stop the recording as well.